Hello, everyone. Hi, can everybody hear me? Okay, good. My name is Lawrence David Au, and I'm with the law firm of David Au, Siegel and Stern. Has anyone ever heard of my law firm before? No. Yeah, you all have, but except you? Okay. Well, we're gonna change your opinion on that soon, because my law firm was started here in Suffolk County in the year 1913. How do I look? I'm looking okay? Not bad, right? By my grandfather, followed then by my uncle, and then my father, and then guess who? Well, nobody was surprised to find out when I got out of law school that I got a job. But everyone was surprised to find out that I took our family practice that was right here in Patchogue, starting in 1913, and I changed it into the very first elder law firm in Suffolk County, and that's something I'm very proud of. I'm also proud that I'm a past president of the National Academy of Elder Law Attorneys. I'm known throughout the country for elder law, but I'm just a local kid here and grew up in the area, went to Belport High School over here. And so it's a pleasure to be here today. Is everybody in a good mood? Yes, great. Are you ready to talk about death and dying? Okay. Well, we're going to be talking about elder law today, and I hope that what I have to say about that, hope you'll find it interesting, and I hope you'll take that information home to your parents. Yeah, right. All right. Well, welcome, everybody. It's a pleasure to be here. This is the COVID era when this is all going on, as you can see, as we all know. Usually I do these seminars throughout Long Island, and I have 75 to 100 people at every seminar, but we're trying to do things differently right now. We've limited the amount of people that can come to our seminars, and of course, we're separating everybody here. I hope everybody feels comfortable. And also, we're taping this today, so I want you to be aware that there's a camera, but that camera is just really on me, all right? I don't think we're going to make movie stars out of you here today, but we want to be able to preserve this, and we also want to be able to spread it out for people who are not comfortable coming out and doing something like this in public. So, and as you know, there's a lot of people still hunkered down, and for some people that's the right thing to do. But in any event, I'm going to be talking for about an hour and a half today about elder law and estate planning issues. In your packets, there's an outline giving a lot of the information and the numbers that I'll be saying. I will tell you right now that I don't follow the outline, so don't worry about that. But you can take it home with you, and some of the numbers I'll be throwing around will be in that outline. Okay? Yeah. I like that. Okay. Also in your packets, there's some blank pieces of paper. There's pens on the table, so feel free to write notes as we go along. I'm not taking questions as I speak, because I have a story to tell, and I want it to be uninterrupted. But at the very end of my presentation, after I completely finish, I will open the floor to questions, and you can ask all those questions at that time, okay? Also in your packets is an evaluation form. No one's allowed out of here alive at the end without filling that out. I need feedback and knowing if I'm doing a good job up here, and if I'm speaking about the things that you want me to speak about, or if I missed something, I'd like to know about it. Fair enough? Yes. Okay. So without further ado, let's get going. What elder law is all about is addressing the specific legal concerns that seniors may have. Seniors want to know, how can they manage their assets if they become incapacitated? How do you manage your medical decisions if you become incapacitated? Do you need a will? Is the will you have now okay? Should you be updating your wills? Or should you be trying to avoid probate altogether? How do we minimize estate taxes? That's all under the elder law umbrella. But perhaps what elder law has become best known for, well, when I first started doing these seminars over 30 years ago, I used to call it the $64,000 question. But now with a little inflation, it's the $164,000 question, it's the $200,000 question, and that is, God forbid we ever had to go to a nursing home or have expensive home care, how are we going to afford with almost $200,000 a year that it costs without losing our homes and everything we worked a lifetime to acquire? Is anyone interested in this stuff? All right, I'll stay. I'll stay a little longer. Yeah, I don't know why we worry about paying for nursing homes and all this. We have Medicare. Medicare pays for a nursing home, right? No? Medicare pays for a nursing home, right? Yes, Medicare pays for a nursing home. But first you have to be where? Where? In a hospital. Okay, expert, you ready? No. I'm going to embarrass you. For how many days do you have to be in the hospital? For how many days do you have to be in the hospital? 30. Look at me, my friend. Oh, 30. Okay. Nope. 3 days? Yes, you knew it. I knew you knew it. So you have to be in the hospital for 3 days. That's it. And upon leaving the hospital, you have to get into a nursing home soon, like about 30 days. And in the nursing home, you have to receive skilled care that's rehabilitative in nature. And if you pass that very strict test that Medicare has, Medicare will pay fully for your nursing home. Forever? Do you believe me? No. They will pay fully for 20 days. And then from day 21, they will continue to pay up to day 100, but you have a coinsurance payment of $176 a day, comes to about $12,000, $13,000 out of pocket. If you have a Medigap policy or one of those Medicare Advantage plans, you'll be fully covered then. So up to 100 days. Now, if you go directly from your home into a nursing home, how much does Medicare pay? 0. Okay? If you go to the hospital first, you're there for 3 days, you leave the hospital, you get into a nursing home within 30 days, and in the nursing home, you only need help with the activities of daily living. Helping walk, eat, getting out of a chair, getting to the bathroom. How much does Medicare pay? Nothing. The care must, after 3 days in a hospital, you must receive care that's skilled and rehabilitative. The design of Medicare was to, all right, you got sick, you went into the hospital, you're weak, we're going to get you into a nursing home for rehab, we're going to get you rehab, we're going to get you healthy, and we're going to get you home. But as soon as they go to you and say, Mrs. Jones, I'm sorry, but you're not benefiting from the rehab anymore, you get cut off Medicare. So you're not guaranteed 20 days, you're not guaranteed 100 days. You are guaranteed only up to 100 days if the care remains skilled and rehabilitative. So it may be after 5 days you're not getting rehab anymore, it doesn't help you, you're off Medicare. Or after day 25, or after day 55, or after day 85. But if you're lucky enough to get Medicare to pay for the full 100 days, that's it. After day 100, if you need to continue to stay in the nursing home, then you're on your own. You have to pay for it yourself, and these nursing homes are costing about $160,000 to $200,000 a year. And the average stay in a nursing home is about what? Anyone know? It's about 3 years now is the average stay in a nursing home. So for the average stay here on Long Island for a nursing home is about $500,000 to $600,000. This is a crisis for middle-class seniors and their families. Middle class, working class, even upper middle-class people get wiped out or partially wiped out because they get the wrong disease in this country that ends up needing long-term care. And it's just not right. It's just not right. The wealthy don't worry about this. And I will tell you that although we represent in our law firm the wealthiest people on Long Island doing all their very fancy estate tax planning, we have a section of our law firm that does that. That's not elder law. That's tax planning. Wealthy people don't worry about nursing homes and home care and all the expenses that go with long-term care because they just pay for it. They can pay for it out of their income. They don't worry about things like this. So I'm not going to be talking today about the wealthy. And you have to be really wealthy to even have an estate tax issue. The middle class is completely out of the estate tax. The upper middle class is completely out of the estate tax, so most people don't have to think about estate tax. I'm not going to talk to you today about estate tax planning. The federal exemption from estate tax is now $11,580,000 per person. So a couple over $22 million exempt. It doesn't affect too many people, does it? And the New York exemption is now $5,850,000. So you have to have almost over $6 million to have a tax issue here in New York. So that's not most people. If you want me to put on a seminar for estate tax planning for the affluent, I'm happy to do it. I do a lot of it. I do it in the law firm. But I concentrate my life to elder law to working and middle-class people dealing with the issues of long-term care. And we know Medicare is not going to help. So we're going to talk about today about how we can address long-term care issues and general estate planning, how we do it for a middle-class senior today, upper middle class, someone who's not in a taxable estate, okay? All right, so what I find, my clients come to me and say, Lawrence, look, here's the problem. I know I could face all these expenses for long-term care someday, and I want you to know something, and I want you to solve it, and here's the problem. I don't want to pay for it. I want someone else to pay for it. Well, who is out there that would pay for it? Medicaid would pay for it. Who else might pay for your long-term care? Private insurance, that's correct. So the first thing I want you to know, and that's it, by the way, people, either you pay for it yourself, you buy insurance to pay for it, or you try to get on Medicaid to pay for it. And I'm going to teach you about this whole Medicaid thing today. But the first thing I want you to know is that I believe that every single one of you in the room here should buy long-term care insurance. Every one of you who can afford it. And every one of you who's not old enough, is not too old to get it. Once you're over the age of 84, you can't get it anymore. And you can't have any pre-existing conditions. In other words, they don't sell you fire insurance when they smell smoke. All right, bottom line. So if you've got a little osteoporosis, arthritis bothering you, you're probably not going to get long-term care insurance because they think you are a greater risk of needing help as you get older. You got to present yourself as extremely healthy, but it's expensive. If you can buy it, buy it. I think it's better than what I do for a living, which is Medicaid planning. And for you cynics in the room who I'm saying, oh, he's saying to go buy insurance, and now you think I sell it. I do not sell long-term care insurance, and I don't even have a relative that sells long-term care insurance. But I believe in it. I think long-term care insurance is better than relying on the Medicaid system. I don't think the Medicaid system may not be here in the future as we know it, and you may not be able to access it. It's because it's a program for who? For the poor. And I'm going to teach you today how you can become poor, but I don't know how much longer I'm going to be able to do that. And for 30 years, I predicted the end of this. And for 30 years, I've been wrong. And they've let us continue to do this. And it could be for the next 30 years they will. It may be that someday we wake up and they have universal health insurance in this country, and everybody is insured for their long-term care under the Medicare system or some expanded Medicare system. But are we going to hold our breath right now for that? I wouldn't think so, and you may not see it in your lifetime. But someday I think we may have that. It's expensive. Our taxes will go up to pay for it. Are we willing to do that? I don't know. Maybe not. But be that as it may, it's not here today. I'd love you to buy long-term care insurance. I think it's better than Medicaid, but it's too damned expensive. Most people can't afford it, and many seniors can't get it because of some health history. We all got something. So I bought it for myself when I was 45 years old because of everything I've seen. And if you don't get it for yourself, talk to your kids about buying some form of long-term care insurance when they're younger and healthier and it's more affordable. But if insurance is not on the table, then the only thing left on the table is Medicaid. And that is what I do for a living. I help people pre-plan to get on Medicaid, and in a crisis, get them through Medicaid to be able to protect as much of their assets as they possibly can. All right, so to get on Medicaid, I've already told you this, you have to be what? Poor. How poor do you have to be? Dirt poor is correct. Dirt poor, damn poor, indigent, have nothing practically. In fact, you can't have more than $15,750 in your name. $15,750 in your name. And by the way, that includes the value of your home. Now, if you're married, they look at you as a couple. If one of you needs Medicaid, that person still only is allowed $15,750. But then they look at the spouse at home. The home is an exempt asset as long as a spouse is living in the house. And the spouse is allowed up to about $128,000. But there's more that we can do, and I will get to that as I get a little further into this. But basically, you have to be poor. So let's say you came in and you said, all I have is $15,750, and I have a house, and you need a nursing home today. What would happen? I'd get you on Medicaid, but Medicaid will put a lien on your house until the equity is gone. You'll lose the house. Or you don't lose it, the kids lose it. And you may not care about that. Or you might care about that. Okay? So if you are married, your house is exempt. If you're not married, they're going to put a lien on your house until it's gone. Well, don't sit back and say, I'm married, I don't have a problem, because if one spouse dies and the second spouse ends up getting sick, we could still lose the house. All right, so you say, look, Lawrence, I've got a house, I've got some money I put aside, I'll never get on Medicaid. But what if you do this? What if you take your house and you take your money and you just transfer it all to your kids? And by the way, they'll take it. The next day, you've given everything away, you're poor, you're under $15,750 in your name. Are you now eligible for Medicaid? What's the answer? No, you're not eligible for Medicaid because they're not that crazy. They know, they're on to you. It used to be years ago that you could just apply for Medicaid. If you're poor, you're eligible. But then they said, wait a minute, oh no, we know you just gave everything away. And so they decided we're going to penalize you something. If you give away your assets, you can't just apply for Medicaid the next day. There's a penalty for giving away your assets, a Medicaid penalty. The penalty is not a dollar amount you have to pay, but it's an amount of months you have to wait before you're eligible for Medicaid. How many months, people? Let me hear it. Any answers?
5 years.
I hear 5 years. Do I hear 7 years? Anybody? Tell you what, let's vote. Let's vote. I love voting. You ready? Raise your hand if you say it's 5 years, 60 months. Interesting. That's more than half the hands. Interesting. Who says it's 7 years now? I see 4, 5 hands going up, hands down. Who says it's 3 years? No. Who says it's 2.5 years? Who says, I have no idea? And who says, I don't give a damn, I came for the pastries. Get on with it. I had nothing to do tonight. All right. Would you like to know the answer? Yes. The actual answer is, it depends. Is that a lawyer's answer or what? What does it depend on?
Your age.
Not your age. How much money did you transfer out of your name? How much money you transferred out of your name. And the real penalty is that you are not eligible for Medicaid for 1 month. For every about $13,000 you transfer out of your name. For about every $13,000 you transfer out of your name, you are not eligible for Medicaid for 1 month. Let me give you an example. You have $130,000 in your name. You write a check to your children for $130,000. What is your Medicaid penalty? 10 months. $130,000 divided by 13,000, we come up with 10. Just get the calculators out and the phones, and 10 months. If you gave away a $260,000 house, it would be 20 months. If you gave away $1,300,000, it would be 100 months. You take the value of what you gave away, divided by 13,000, that would be your penalty. Who said 5 years? Don't be afraid to vote the same way, because those who said 5 years were the closest to the truth. There's not a 5-year penalty, but it feels like a 5-year penalty Because there's not a 5-year penalty, but there is a 5-year look-back period. And the look-back is different than the penalty. Being very technical, but I want you to walk out of here really understanding it. The look-back period is the Medicaid doesn't trust you law. You can't just go into Medicaid and say, hey, Medicaid, I've got nothing. So give me Medicaid. Pay for all of my care. And they're going to go, we don't trust you. We know that you gave away your money. But if it was more than 5 years ago, it was beyond the look-back. Your assets are protected. So it feels like a 5-year penalty because all you need to do is get your assets out of your name, wait 5 years. Once it's beyond the look-back, there is no penalty. You're immediately eligible for Medicaid. But if a transfer gets caught in the 5-year look-back, then there's a penalty of 1 month for every $13,000 you transferred out of your name. Let me give you an example. Today, 3 years ago, you wrote a check to your kids for $130,000. 3 years later, you end up in a nursing home unexpectedly. Are you now eligible for Medicaid? Answer?
No.
And the answer is no, you're not eligible for Medicaid. Why? Let's go through the test. Test number 1, question number 1. What is the look back? 5 years. That's an audit period. This is what we do in our office for our clients. This is like having a full-blown IRS audit. Clients come into our office, and we do the entire audit. We present the case to Medicaid. We have to do a 5-year complete audit of your financial life. If a transfer was before the 5 years, then we don't worry about it. But here, we're going through the audit, and Medicaid is going to say, aha, you transferred away 3 years ago. We caught it in the look back. You gave away $130,000. What's the penalty? 1 month for every 13,000 transfers. So if you transferred 130, that would be 10 months. So your penalty is 10 months. When does the 10-month penalty begin? Is it the day you gave away the money? It used to be. Now it's the first day you're in the nursing home and apply for Medicaid. You apply for Medicaid. They say, aha, 3 years ago you gave away $130,000. Your penalty is 10 months. That means for the first 10 months of the nursing home, you are not eligible for Medicaid. You'll be eligible after the 10 months. So then what we have to do is we have to get the money back from the kids. That could be a problem. But let's assume your kids are angels. That's not the problem. So they give you the money back. Now, if you did no planning or if we had to give the money back, I want you to know that even at the last minute, under current law, we can save 35 to 50% of the money at the last minute. We call it the half loaf approach because we're saving half a loaf and not the whole loaf. But if you want to save the whole loaf, you need to get the assets out of your name, get the 5-year look back started, and get the 5-year look back over with. Now, when I talk about this 5-year look back, I'm talking about Medicaid paying for a nursing home. Medicaid pays for more than just nursing homes. They pay for care that you might need outside of a nursing home, which we call community Medicaid. And in real terms, what that means is that an aide is coming into your house and helping take care of you. Or it could be adult daycare, where a van will come get you in the morning, get you out of bed, get you dressed, bring you in the van, bring you to a facility where you get your a shower and you get some rehab and you get some socialization, and at the end of the day, brought back home, back in pajamas and back in bed. That's adult daycare. Or a few days of adult daycare and a few days of an aide coming into the house. And we've had aides for 4 hours a day, 7 days a week, and we've had aides for 24/7. Hard to get 24/7, but it's doable. The rules for Medicaid, for community Medicaid outside of a nursing home are different than the rules inside a nursing home. And if you are applying for Medicaid today, there is no look back for Medicaid home care. You can just give away all your assets today and be eligible for Medicaid the next day or the first day of the next month. Doesn't that sound incredible? Well, you have 1 week to act on that. Because as of October 1st, 2020, there will now be a 2.5-year look back for Medicaid home care. They changed the law. As of October 1st, there is now going to be a 2.5-year look back or something that looks like one. It'll work the same way as the nursing home one, except if a transfer is made before October 1st, 2020, it'll never be counted. It'll never be part of the look back. If you apply for Medicaid after October 1st, 2020, then Medicaid can look back 2.5 years, but they hit a wall at October 1st. Any transfer before October 1st is not counted. So if you applied on February 1st, 2021, there really would only be a 4-month look back because we stop at October 1st. There won't really be a 2.5-year look back until 2.5 years from October 1st, but every month that goes by, the look back will be just a little bit longer. But any transfer you make between now and next Wednesday is free. Any transfer after October 1st is not free. So if you're trying to protect assets right now at the last minute and you've got a big bank account and you want to put it in your kid's name or do something else with it, or trust, or whatever you're going to do, you got to do it before October 1st. Otherwise, you have a look back that will be the greater of, or the lesser of October 1st and then 2.5 years, or whatever. You know what I mean? Okay? So, in the real world, as of next week, we're going to have a 2.5-year look back for Medicaid to pay for home care and community Medicaid, and a 5-year look back for Medicaid paying for a nursing home. I want to make something perfectly clear. Again, if I haven't mentioned it already, I am not here today saying you should be getting all your money out of your name. Because that doesn't have to be your goal to get on Medicaid. You just may say, look, I believe that I should be paying for my own care. And if I run out of money to paying for myself, so be it. There's nothing wrong with that thinking. That's your value system. My experience as an elder law attorney is that that's not the way most people think. Most people are saying, I would really like to protect money for my kids. But people are nervous. If they got everything out of their name to protect it for their kids, what's there for themselves? Now they're going to feel insecure and vulnerable. So the question is never, how much should I transfer to my kids or to a trust or get it? The question is never, how much should I get out of my name? The question is, how much do you want to keep in your name? What do you need to keep in your name to feel independent and secure and in control with dignity? Now, it depends on your income. If you have good income and you never really spend your principal, you may say, I only need $50,000 or $100,000 in my name. I want to take my house and the rest of my money, I want to protect it for my kids, as long as I have the right to live in the house. And other of you will say, I won't feel comfortable unless I have $1 million in my name, or $50,000, or $100,000, or $200,000. You're all going to be different. And stop listening to your neighbors and your friends and your brothers and your sisters. Their opinion is irrelevant. Oh, they'll say, I did this, I did that, you should do that too. It's irrelevant. We're all different. We all grew up differently. All the things that happened to us in our lives created the crazy way we look at the world. And it's okay the way you look at the world. It's your way. Stick to it. Don't listen to the noise from other people. Check into your values. If you're a control freak, be a control freak. Okay. Be a control freak if that's what you want to be. If you want to protect assets for your kids, protect assets for your kids. All right. So, we've learned that you can transfer money out of your name, and if you get past the lookbacks, you will then be eligible for Medicaid after that period of time. All right? But you got to play the game here. One asset you don't have to worry about, or one type of asset you don't have to worry about, and that's your retirement plans. all of your retirement plans, your IRAs, your 401ks, your 403bs, anything where you earned money and you didn't pay any tax on it, and you put it into one of these vehicles that has letters and numbers on it, and you tax deferred, and at 72, you have to start taking out minimum distributions. Anything like that is exempt from Medicaid. You could have $1 million sitting in an IRA, it is exempt from Medicaid. Doesn't count toward the $15,750 you're allowed to have. But you are required to take out your required minimum distributions. Medicaid will get your income. Medicaid gets your Social Security, Medicaid gets your pension, and Medicaid would get the minimum distributions from your retirement plans. If you have a spouse and the spouse has very low income, there is a way to shift some income over to the spouse. But for the most part, income is a problem. If you're asking for Medicaid to pay for home care, very often I can save all the income. We do it by shifting the excess income into a pooled trust maintained by a charity. The charity has this pooled trust. What is a pooled trust? It's where they're going to take your income and pool it with everybody else's. So it's one big pot of money. And you put your income in that every month. You submit your bills to it every month. They pay your bills. So you're legally washing your money, laundering your money right through this charity. You're allowed to do it. So we can save the income by using this pooled trust, only in a home care situation, not in a nursing home situation. All right. Now, if you're married, there are some other rules. So let's say we have a husband and wife. By the way, it could be a wife and wife, a husband and husband, doesn't matter anymore. Same for everybody. But let's say we have a husband and wife, and the husband has, together they jointly have a house in this area here around, today we're in Bellport. Let's say the house is worth $400,000, it's jointly held. And let's say they have $300,000 of other money in the bank. Just one big fat savings account with $300,000 in it. Plug in your own situations here. Husband has a stroke. He ends up in a nursing home. By the way, in all of my examples today, the husband is going to get sick first. And the husband is going to die first. Why do the men die first? Because they want to. That's correct. That's correct. All right. So, I'm kidding. All right. So, husband has a stroke. He ends up in a nursing home. Is he eligible for Medicaid day one? What do you think? Jointly held house. Jointly held $300,000. Husband's in the nursing home. Is he eligible from what I've told you already? Is the house a problem? No. I told you, as long as the spouse is living in the house is an exempt asset. House is not a problem. Good. All right. And now we have the $300,000. Is that a problem? Yes. How much money did I say he could have in his name? $15,750. At least half of that will be allocated to him. So he's not eligible. But the first thing we're going to do is we're going to take the house, and we're going to take all the money, and we're going to transfer it over to the wife. Can we do that? Let's break that down. Let's break down the issues. First of all, he thinks that Roosevelt is the president. He can't sign his name, transferring everything over to his wife. How are we going to sign his name? A power of attorney. Good. What type of power of attorney? A durable power of attorney. What does that mean? It means it's tough, it hangs in there, it's durable. If you become incapacitated, your agent can still act for you. That's all it means. It's one line in a power of attorney saying the power of attorney is still good if I become incapacitated. That's what that means. So let's say that she has a power of attorney over him. So can she use the power of attorney to take the money and the real estate out of his name and put it in her name? What's the answer generally? Absolutely not. Not. Because an agent is supposed to act for you, not steal your money. So the agent isn't allowed to take and worse, she not only cannot get the money out of your name, but she can't take it for herself. Because that's stealing it. That's self-dealing. An agent's supposed to be loyal to you, not steal you blind. But if the power of attorney specifically says that the agent can make unlimited gifts of your assets and can self-deal and take things for themselves, then it's allowed, but you have to see it in there. So you want to look at your powers of attorney and make sure that those provisions are in your power of attorney. So in this case, she's got a David Howe power of attorney. She's got the right one. So she's going to use that power of attorney, and she's going to take the house and all the money out of his name. It's now all in her name. She's got the house. She's got the money. He's down to $15,750 or less. Is he now eligible for Medicaid? What do you think? Absolutely not. Because they look at you as a couple. They look at you as a couple, and they're going to say, all right, you're down to $15,750, husband, but wife, you got too much money. Yes, the house is exempt as long as the spouse is living in it, but you've got $300,000 sitting in your name. That's not going to work. That $300,000, Medicaid will tell you, you must spend it down until she's down to $128,000. If you call up Medicaid right now, they're going to say, lady or husband, whoever it is, you need to spend the money on the nursing home, and when you're down to $128,000, then we'll give him Medicaid. But I want everyone to repeat after me. You ready? I want to hear you. Don't embarrass me. This is on tape, all right? Medicaid. Medicaid. Good. Is the enemy. You don't listen to your enemy when you're trying to protect your assets. You listen to Lawrence. And there's our theme. There's our theme. Listen to Lawrence. And what Lawrence is going to tell you about, well, after all these years, I'm still calling it the Nancy Reagan exception. What was she known for having said? What was her thing? Anyone remember?
Say no to drugs?
Say no, right. Just say no. And that is the advice I'm going to give the wife at home here, whatever spouse at home. Just say no. Say Medicaid. No, I'm not paying for his care. I'm not spending down my money to $128,000. I refuse to pay for his care. And what the wife is doing here is technically called spousal refusal. And this might be something the husband already knows about. Let that one go. All right. So she's at home, she's got the money, and she says, I refuse to pay for him. Or she could be in the nursing home, and he is at home, he refuses to pay. Same thing. Once the spousal refusal is on paper and delivered to Medicaid, the spouse in the nursing home, in this case the husband, gets Medicaid. Even though she's got $300,000, even though she's got $500,000, even though she's got $1 million, all the spouse at home has to do is say, I refuse, and now he's on his own. The spouse at home's money doesn't count. The spouse in the nursing home gets Medicaid. However, sounds too simple, right? Medicaid has a right to sue the spouse at home to support the spouse in the nursing home. In sickness and health meant something. But they have never brought such a suit in Suffolk County. There's been none of these spousal refusal lawsuits in Suffolk County. They used to do it in Nassau, but they stopped over 2 years ago. And throughout the other counties of the state, it's sporadic. But they've never done it here in Suffolk County. Why? Because it's bad policy and bad politics. Bad politics. You're going to take this little old lady, this little old man, and bring him into court and impoverish him? That doesn't sound right. You can't impoverish both of them. What good is that going to do to society? So they don't bring these lawsuits. It just doesn't look good, doesn't make sense. But every year in the budget, they threaten to get rid of spousal refusal or to aggressively do these lawsuits. And at some point, it's going to happen where we can't do this anymore. I really believe that. They're going to get rid of this at some point. There's very few states in the country that allow spousal refusal. We're in the big minority. And with these days, with all the money we just spent on COVID and everything else, we don't have the money for all this. So I don't know what the future is going to be. I think it's going to get harder and harder to get Medicaid in the future, and I think they will pass laws in the future that will take away spousal refusal. But right now, that's what I'm doing if you're in a crisis. But I don't want you being in a crisis. I want you to do pre-planning. If you can walk in here today, I want you to do pre-planning. If this is your concern. If you want to protect your assets, you should do pre-planning. You get your look-back started, you get your look-backs over with. Okay? All right. Are we having fun yet, by the way? Isn't this fun? All right. I told you death and dying would be fun today. All right. All right, so that's the basic eligibility rules to get on Medicaid, okay? So let's switch gears now and let's get into some planning, okay? And what is the asset that most people are trying to protect? Most middle-class families. What is the asset they're trying to protect? The house. The house is the major asset that most people want to protect. In fact, your typical client, my typical client, have two types of assets. And of course, there's many other varieties. But most of my clients come in and say, look, I have a house and I have a retirement plan. Because it's hard to live here on Long Island. It's an expensive place to live. And the forced savings is what we end up with after we educate a few kids and live here on the island. And what do you forced savings is they took the money out of my paycheck every month and they put it in my 401k. And it built up over the years. And I paid off my mortgage little by little over 30 years. And now I've got a house paid off and I've got an IRA. Typical client. Well, that particular client doesn't have to worry about the IRA because IRAs are exempt from Medicaid. It's only the house. So typically, my clients are coming in and say, I want to save my house. If they have other assets they want to protect, then of course we deal with that as well. But I want to start with the house here. So let me explain how we do this and protect the house. The house, let's say you bought it years ago. Use your own numbers. I'm just going to put some numbers on the table to get you to understand it. Let's say you paid $50,000 for your house years ago. What you paid for your house in tax law, does anyone know what that's called? That's called your basis. Your basis. That's where we start from, the base, okay? The basis. Now, you paid $50, that's your original basis, but through the years, new roof, new bathroom, new kitchen, new siding, a pool, whatever you put into the house, let's say you put another $100,000 into the house through the years. So you paid $50 and then you really paid another $100. So you paid $150,000 into this house now and your basis is now $50,000. Okay? So now the house is worth $400, let's say, and the difference between your basis and what it's worth is the profit, or what we call what? Capital gain. That's right. That's the capital gain. And in this case, it would be $250,000 of capital gain. All right, good. And if you sold your house and you had $250,000 of capital gain, would you pay any tax? No, because everybody gets an exclusion of how much on the sale of your principal residence? $250,000 per person. So as a couple, you're right, at $500,000. But we're not talking about selling your house right now. You're talking to me about protecting your house right now. And so what happened is your kids came over last weekend, and they said, "Hey, kiss Grandma, kiss Grandma and get out of here, because we need to talk to Grandma and Grandpa. Mom, Dad, we're real concerned about you. We're worried if you get sick, but you could lose your house. So we have a great idea. Put the house in our name, and don't worry, we'll let you live there for the rest of your life." Never, ever put your house in your kids' names. Ever. Shelter is a primary need. Never lose it. And now I'm going to give you all the reasons why you should never, ever, ever put your house in your kids' names, outright giving it to them. So let's go back to my tax thing here. You have $250,000 of capital gain built into your house above your basis. If you give the house to your kids while you're alive, yes, 5 years later, it'll be protected from Medicaid. But if you give the house to the kids, you're giving them your basis. And if they sell it while you're alive or after your death, they get the $250,000 of capital gain. But what don't they get? They don't get your $250,000 exclusion. Why? Because it's not their principal residence. So you're causing them a tax of around 22%, or over $50,000 in tax. You don't want to do that. The second reason is, if you transfer the house to your kids, you're going to lose your STAR exemption, maybe your enhanced STAR exemption, senior exemptions, veterans exemptions, all your write-offs. That's the last thing you want to do, is have your property taxes double overnight when you live here on Long Island on a fixed income as a senior. And the last reason, but people come to me and they say, "Look, Lawrence, I love my son. I trust my son. So I'll give the house to my son. Here, son, take my house. And the son is very happy about it, and everyone's very happy, and then the son dies. And now your daughter-in-law owns the house. And what's worse than that, she remarries a lawyer. Goodbye, Grandma. Goodbye, Grandpa. You're out. Never lose control of your house, period. Now, if you never give away your house and your children inherit, or your family, whoever you're giving it to, inherits the house, remember your basis? We had that 150 basis worth 400. If someone inherits the house, they get a new basis, a step up in basis, stepped up to the value of the date of death. If someone inherits it, their basis would be 400,000. And if you sell the house for 400,000, what's the capital gain? 0. Death is the best tax shelter. So you wipe out all the capital gains at the time of your death. But if you hold on to your house so you can wipe out the capital gains and you end up in a nursing home, you could lose the whole house. So we need a solution where you're getting the house out of your name now and getting your look back started and getting your look back over with, while at the same time keeping your control, wiping out the capital gains, and keeping all your property tax exemptions and write-offs. Is that too much to ask? You want it all, like all my clients. All right. There are 2 tools in the tool shed that will let us have all of this. I'm going to describe these tools, but believe me, then it's not one or the other may not be right for you, and it's possible that both will be wrong for you. So I'm not trying to sell you on the idea that you have to do one of these, because everybody's different, as I said before. All I'm going to do is I'm going to describe the 2 tools we have in the tool shed and some of the pros and cons of them. Okay, fair enough? Does anyone know what the 2 tools are? One is a life estate, correct. That's usually the harder one to guess. And the other one is a trust, correct. Life estates and trusts. So let's start with a life estate. A life estate is a relatively simple thing to understand. It's where you do a new deed to your house, you transfer the house to your kids or whoever you want it to go to, but in the deed you reserve a life estate, the right for you to own it and live there and enjoy it for the rest of your life. What you're giving away now is the inheritance. They own it subject to the fact that they're stuck with you for the rest of your life. At the time of your death, your life estate goes poof, it's gone, and immediately your kids or whoever you gave it to owns 100%. Medicaid says that was a transfer of your asset. You transfer it, retain a life estate, that is a transfer subject to the 5-year, or for home care, 2.5-year look back. Okay? After the 5 years is over, the house is protected. But you have a life estate. You have the absolute right to live there. Nobody can kick you out. Nobody can sell it out from under you. It's your house for your lifetime, and you have the obligation to pay the taxes. And because you have the obligation to pay the taxes, you also get all of your property tax exemptions. Okay? At the time of your death, your life estate is extinguished. Your kids now own it immediately without another deed necessary. We avoid probate in the process. And you get the step up in tax basis, or the kids do. They get the step up in tax basis, wiping out the capital gains. Oh my God, this sounds so good! But there are problems. It's not right for everybody. You know, let's say that you're now 80 years old, you did a life estate 5 years ago, more than 5 years ago, your house is safe, it's protected, you're happy, you're here in the summer on Long Island, and you're doing what you do every summer. You're in your backyard, and you're tending to your beautiful little garden of beefsteak tomatoes. And this is your pride and joy every year. You're in your backyard taking care of your little beefsteak tomato plants. And these are not just any beefsteak tomatoes. These are big, they're juicy, they're meaty. These would win first prize at a state fair. This is your pride and joy. And you're taking care of, you're down on your knees taking care of your tomatoes. And you can't get up. And a tear comes to your eye and you say, oh my God, this is probably my last crop. I need to sell this house. I can't live in here anymore. I can't even get up. My spouse died a couple of years ago. It's getting kind of lonely here. The house is too big. My friends are all dead or in Florida. And the realization comes to you that for whatever reason, you need to sell your house. If you sell your house, who gets the money? And the answer is, it's split between you and the kids. Because you didn't give 100% of the house to the kids, you kept something. You kept what? A life estate. And that has a value. It's a percentage value of the property. And what's the percentage? Well, it depends on how old you are. The older you are, the less your life expectancy, so the value of your life estate gets less and less every year. But let's say at 80 years old you sell it, and you find out that your life estate is worth 10%. So you get back 10%. Oh my God, it's like a hot potato. You just spent over 5 years getting rid of the house. Now you got this 10%. What do I do with it? Kids, you take it. Another 5-year look back. Or if the reason you're selling it is because you're not living there anymore and you need Medicaid, you're going to give that 10% to Medicaid. And the other 90% you're giving to who? Your kids. They're selling the 90%. And it's not their principal residence, so they have to pay 90% of the capital gains tax. Disaster. So here's the bottom line. A life estate is a cool tool to use. But you don't use it, you never do a life estate if you want the flexibility of selling the house during your lifetime. Because there's problems. There's Medicaid problems and there's tax problems. You don't do a life estate if you want the flexibility. And I have people all the time saying, I'm never going to sell my house. Well, there's a lot of people who sold their house saying they would never sell their house. I love when I have couples in front of me. And I'll ask the couple, you ever going to sell your house? They look at each other and they know that the right answer is, we'll never sell the house. And I go to the husband, if she dies, what are you doing? Selling it in a minute. I've been wanting to move to Florida for years, but she makes me stay here because of the grandchildren. Never say never. Now, there are people who know they're not moving. They're going to stay here. If they're not living in the house, they're still not going to sell it. They're going to a grandchild to move in. They'll take care of it. My kids live next door. They'll watch the house. They'll rent the house if they need to. If the facts and circumstances work out, then you may not sell it. I've got people in my, let's say on the Forks in the Hamptons and the North Fork of Long Island, that they sold their house up island somewhere and they're living out there now. They'll never sell that house. That's the beach house. That's the summer house that they want their children and grandchildren to enjoy for generations after they're gone. That'll never get sold. A life estate may be the right tool in the tool shed. But if you want the flexibility of selling the house during your lifetime, a life estate is the wrong tool. We move on to the next tool, and that's a trust. How many of you have even seen a trust before? One couple here, all right. So I'm going to give you the David Howe Law School Trust 101 class in 5 minutes. You ready? Gear up. Here we go. A trust is a contract that you make with somebody you trust to hold your assets for you while you're alive and distribute those assets after your death. It's a contract that you make with somebody you trust. That person you trust is called the trustee. It's a contract you make with a trustee to hold your assets. The trust will say what they can do with those assets while you're alive and what the trustee should do with those assets after your death. A trust is a will substitute. The same language that would be in your will would be in your trust. Upon my death, I leave everything to my children per stirpes, which means that if any of my children predecease me, their share will go to their children, maybe in a continuing trust until they reach the age of 25 or something like that. It'll be the same language that would have been in your will. Okay? So, if the contract says that you retain the right to get rid of the contract, that's called a revocable trust. If the contract is set in stone and you can't get rid of it on a whim, that's called an irrevocable trust. It's that simple. It's that simple. Okay? All right, so once you and the trustee sign this contract, though, it brings to life an entity, or something like an entity called a trust. So when you and the trustee sign it, the trust is born, and it's born owning nothing. The trust only controls assets it owns. And when it's first born, it doesn't own anything. So Lawrence Davidow wants to save his house from Medicaid. Let's go through an example. So I've got a house in my name, Lawrence Davidow, and I'm going to do a new deed, transferring the house out of my personal name into the Lawrence Davidow Revocable Trust. Now, by the way, in a revocable trust, by the way, you can be the trustee of your own trust. So I could sign as the grantor, setting up the trust, and as the trustee. I'm in full control of my trust. It brings to life the Lawrence Davidow Revocable Trust. I'm in full control. Awesome. My house is now owned by this trust. 5 years go by. Is my house now protected from Medicaid? What's the answer? I would say yes. Probably no. I would say yes, probably no. And the answer is no. The answer is no, because you never gave away the house. What do you mean I never gave away the house? I took it out of my name, I put it in my revocable trust. But that means you could get it back whenever you want. If you can get it back whenever you want, it's a revocable trust. You can revoke it and get it back. If you can get it back, Medicaid can get it. You never gave it away. The 5 years never started. Revocable trusts do absolutely nothing to protect your assets from Medicaid. Nothing. Revocable trust will not save you a dime, not a dime in taxes. Because you never gave anything away. You took things from your left hand and you put it in your right hand. It's still your money. And you're going to be taxed on it. Income tax, estate tax, all of it. All right. If revocable trusts don't help us for Medicaid or for taxes, why are they popular? Why do them? Why are they popular? I do lots of them, but why? What do they accomplish? What's that? Liability? No, it's still yours, so you still have full liability. And the answer is, it's not so much what it accomplishes, it's what it avoids, which is what? Probate. Setting up a revocable trust means you're going to avoid probate. What is probate? Probate means that we have to use your will. Your will is a worthless piece of paper when you die. It's worthless. It doesn't mean anything until you bring it into court and go through a court process and get the blessing of the judge that this is indeed your last will and testament and it was properly done. And then once the judge is satisfied, he'll give a piece of paper to the executor, so the executor has the power to collect all your assets and pay your bills. But you only need to go through probate if an asset doesn't know where to go. If all of your assets are in a revocable trust, if all or are joint with somebody so that it automatically passes to the joint owner, or it names a beneficiary. You have beneficiaries on your retirement plans. You have beneficiaries maybe on bank accounts. All avoids probate. And if every single one of your assets avoid probate, you don't have to probate the will. Because everybody got the money already. Anything in the trust avoids probate. So there are cases where it makes sense to avoid probate, especially if your probate is more complicated or more expensive than a normal probate. And there are lots of factors that do that. Especially if you have real estate in 2 states. You have to probate in every state where you have real estate. So if we want to avoid probate, we can set up a revocable trust. Maybe, maybe not. Maybe we go through probate. Facts and circumstances will determine that on a case-by-case basis. But that whole probate discussion we're going to put aside for now. We'll figure out later if you're going to do a will or you're going to do a revocable trust. But it doesn't help us from a Medicaid point of view. If you're trying to protect your house and other assets, you would need to do an irrevocable trust. Now, you cannot be the trustee of your own irrevocable trust. So you can pick your children, perhaps, to be, or one of your kids to be the trustee of your irrevocable trust. And by the way, if you can't trust your kids to be the trustee, why are you trying to save your house and money for them in the first place? But let's say you're going to pick one of your kids as trustee. You create the irrevocable trust, you name one or more of the kids as trustee or someone else, could be niece, nephew, anyone you want. You then create this trust. You then put the real estate in the name of the trust. You could put stocks in there. You could put bonds in there. You could put annuities, CDs, money markets, whatever you want to protect can go into the trust. 5 years later, those assets are protected because you can't get them back. If you can get them, Medicaid can get them. These are designed that you can't get it back. But you have the absolute right to live in the house, and I can even design it that you keep the income from the assets in the trust if you want the income. I don't always do it that way, but it can be done. But usually the house goes in there, certainly. You have the right to live in the house. Because you have the right to live in the house, you will keep all of your property tax exemptions, your STAR, your enhanced STAR, your veterans, your senior, and your write-offs. The house cannot be sold by the trustee without your consent. But if you give your consent, the trustee can sell the house. If the trust sells the house, who gets the money? The trust is the right answer. The money goes into the trust, and the trust could buy you another house or a condo or go to Florida or whatever you want to do. You don't need the money from the sale of the house to buy the next house. The trust will have the money to buy your next house. All in there. Okay. Now, you go to your kids. Say, hey, kids, sell the house. And the trustee kid says, no way, Dad. No way, Mom. I want this house someday. I'm not going to let you sell it out from under me. What are you going to do? What would our president do? What would our president do? Let's go back to what the president did before he was president. Actually, he's been doing that. No, I'm sorry. The TV show. What would he do? Fire him. Fire him. In other words, you have the right to fire the trustee at any time and replace him with someone else. Can't be yourself, but you can get rid of one kid, put another kid in. You can get rid of all your kids and have your best friend be the trustee. Even though it's an irrevocable trust, you can change the trustees. Okay? Even though it's an irrevocable trust, you can change the beneficiaries of the trust. So at any point, one of your kids forgets your birthday or something. I'm sorry, kid, you forgot my birthday, you're out. You can change it among your children and grandchildren. You can change the beneficiaries at any time. And understand, if you can change the trustees and you can change the beneficiaries, who's in control of this trust? You are. That's why these things work. Okay? All right. It's getting hot in here, I know. That's because a lawyer's been talking for an hour and a half. It's all that hot air. All right. We're getting toward the end here. All right. So we have these trusts. We have these life estates. You know, it doesn't matter what you end up doing as long as you continue on this quest for education. You learn what you can do, you learn your options, you act on it one way or the other. It doesn't matter which tool you end up using. As long as you thought about it and got good advice and you picked what was right for you. Okay? But the other thing I hear from people is, you know what, Lawrence, you don't understand me. I'm never going to a nursing home. I know this for a fact. I'd kill myself if I had to go to a nursing home. I have pills lined up in my house. I have a shotgun. I will kill myself. Don't you worry about it. And of course, the nursing homes are filled with people who made those claims. And the problem is that some people just put their heads in the sand and they don't do anything about any of this. But if it happened, what it will do to your family emotionally, psychologically, and financially will break your heart. So I beg you to learn about this stuff, and whatever you decide, it doesn't matter. But make the decision. Don't do nothing unless that's your decision. I mean, don't procrastinate. I'll get to it. That's the worst thing you could do because time has a way of happening. The future tends to arrive at some point. All right. A couple of other quick topics that I like to bring up, and then we'll call it a day, because I think there's a lot of information here, and I don't want to overwhelm you too much, even though I've already done that probably. So another common estate planning thing that I like to talk about is, what if you have a child or grandchild with disabilities? Well, they can't inherit money. They may not be able to inherit money because if they get money, they will lose the government benefits that they have, like SSI and Medicaid. They have to remain poor themselves, so they can't inherit. You may say, my kids are fine, but you may have an autistic grandchild. And if the parent dies, your will may say upon the death of, if my child predeceases me, then their share goes to their kid who happens to have autism. Don't let something like that slip by. So if you have a child or grandchild with disabilities, don't let them inherit the money. Instead, you create something called, anyone know? A special needs trust. A special needs trust, or what we call an SNT. It's also called a supplemental needs trust. It all means the same thing. The money goes into the trust and can be used for anything except what SSI and Medicaid will pay for. In other words, all the money can be used for the child to enhance and enrich their lives without them losing their government benefits. If you have a child or grandchild with disabilities, your plan should have a special needs trust in it for that child or grandchild. Okay? The second common thing I like to talk about, and I see this a lot because of the divorce rates in this country. And we have a lot of second marriages, not to mention third marriages. And let's say it's a second marriage and you each had children from your prior marriages. And maybe the second marriage has been for 15 years and one of them dies and their will leaves everything to each other. Everything was joint. Now the surviving spouse gets everything. And when the surviving spouse dies, where do you think that money's going? To her kids or his kids. Now, at the time, she or he said to the first spouse that died, don't you worry, whoever dies second will make sure all the kids get their share. And they mean it, some of you. And even if you mean it, things change. He dies, and then she sits there 10 years later saying, you know what, those kids of his, they haven't called me in 10 years. I haven't been invited to Thanksgiving. Nobody has mentioned my birthday. They don't care about me, and I kind of resent that. And they don't deserve it anymore. Can you see that happening? I see it happening every day. I also have people say, my husband just died. I'm coming over to change the will. There's no way in hell his kids are going to get anything. They're not nice to me. So if you want to protect your kids, you may consider something like, upon my death, I leave assets in a trust for my spouse. And then when the spouse dies, the money can go back to your kids, or maybe your half of the house, or something, or some variation on this theme. Okay? Very popular and the hardest estate planning I have, because there's a lot of touchy issues on this. Okay? Hard to talk about. All right. And the last topic I like to talk about is something called a family protection trust, or a beneficiary protection trust. You did all this great work to protect your assets for your kids, and they blow it. Here's what happens. Hey, honey, guess what? I just inherited $500,000 from Mom. She just died. I got $500,000. Let's buy a bigger house together. And they buy a bigger house together. They commingle all this money. And then 3 years later, they get divorced. Half of everything you just worked for will go to your son-in-law or daughter-in-law. If you want to make sure that the money you're giving your kids is protected from their divorces and their stupidity, you can't give it to them in the first place. Instead, and I have this in my will for my kids, and I haven't met my daughter-in-laws and son-in-laws yet. I'm not sure if anyone would want them, but that's a different story. Nah, I'm just kidding. But I don't leave the money to my children directly. Instead, what I do is I put the assets in a trust for them. So let's say you have 2 kids, a son and a daughter. At your death, half will go into trust for son, and half would go into trust for daughter. The son is the trustee of the son's trust. The daughter is the trustee of the daughter's trust. But they need a co-trustee. So the son's co-trustee is the daughter, and the daughter's co-trustee is the son. Now, to get them, so let's go to the son now. For the son to take money out of his trust during the rest of his life, he needs the consent of his co-trustee, his sister. His sister says, Mom would never want you to take money out for that car. It's too fancy. Brother could say, sign now, or I'm going to fire you. In other words, each of the kids can fire their co-trustee at any time and replace them with an independent co-trustee, which could be a best friend. Can't be the spouse. It can't be a child, but it can be a best friend. So know that because your kid can change the trustee at any time, they can always find a trustee that will do what they want. And they can take money out whenever they want. But if they get divorced, All they have to say is, sorry, honey, all my money is in my parents' trust. I don't have any, this is not my money. It cannot be split in a divorce. It could also give them complete creditor protection and probably estate tax protection as well. Also, let's say your daughter inherits the money, and 30 years later she dies and she leaves it to who? Her husband and his next wife. If you want that money not to go to the son-in-law or the daughter-in-law, you want it to go down to the grandchildren, this trust will do that also. In other words, your kid will be able to use all the money while they're alive, easily to get it out, and upon their death it goes to the grandchildren and not to the son-in-law or the daughter-in-law. That's a family protection trust. It's one of the most popular things going on in estate planning today.